Chapter 79, Trial, Section 960, Time for Trial. The first step in a trial is getting control of the defendant by arrest, or otherwise. The time of trial is largely in the discretion of the court. The order in which cases must be tried on the docket is usually in the discretion of the prosecuting officer. Theoretically, the cause is ready for trial when the indictment is found and returned into court, the defendant is in its possession and arraigned, and issue is joined. In most of our states, a constitutional or statutory provision gives the accused the right to a speedy trial, or discharge by habeas corpus. The Habeas Corpus Act, upon which these provisions are founded, provides that the accused shall be indicted the next term of court or bailed, and that he be tried the second term or discharged. Section 961. Continuance. Though a cause is ready for trial, either party may, if the circumstance justify, be granted a continuance, in the court's discretion, or sometimes as a matter of right. It is only in case of a gross abuse of discretion that a new trial will be allowed for a failure to grant a continuance. In order to obtain a continuance, a motion stating the grounds must be addressed to the court. This motion should usually be accompanied by affidavits showing the grounds. Among the grounds for which a continuance may be granted are the absence of witnesses who will give material testimony, where due diligence has been used to obtain their presence at the trial, public excitement or unfair prejudice against the accused, lack of time to make necessary preparation for the trial, and sometimes illness of the accused or absence or illness of his counsel. In order to obtain a continuance because of the absence of witnesses, testimony is not considered material which is irrelevant, or is merely cumulative, or could be proved by other witnesses present, or is merely impeaching, or is as to character, or if due diligence has not been used to obtain it. There must also appear a reasonable prospect of attendance at the time to which the continuance is asked. Inability of the accused to attend because of his voluntary intoxication is not a ground for a continuance. Section 962. Presence of the accused at trial. As a general rule, one charged with a felony must be present at his trial, during the time when the jury is called and sworn, while witnesses are being examined, when the jury is charged, arguments of counsel are made, verdict returned, and sentence pronounced. His right to be present at these times is such that it is held that a trial without such presence is without due process of law. Some courts hold that the defendant may waive his right to be present. It, however, is not essential that he be present during certain formal matters, such as making motions to quash or for a continuance, for arrest of judgment, or for a new trial, etc. Nor is it necessary that he be present during the consideration of his appeal by a higher court. Where the accused is on trial for a misdemeanor, his presence at the trial may be waived. The defendant should not be unnecessarily manacled or restrained at the trial, or if so, he will be entitled to a new trial for this cause. Section 963. Change of venue. As a rule, the accused must be tried in the county in which the offense is alleged to have taken place. At common law, and by statute in most states, if the accused can show by sufficient proof supported by affidavits that he cannot have a fair and impartial trial in the county of the offense, he is entitled to a change of venue, that is, to have his trial in an adjoining county. The state may usually file counter-affidavits, but it is held sometimes that this may not be done where the ground of change is prejudice of the judge. It is usually held that where the motion is made on this ground, the change should be granted as a matter of course. One only of several defendants may be granted a change of venue. Section 964. Publicity of trial. The Constitution of the United States and the state constitutions grant to persons accused of crime the right to a public trial. Such a provision is for the benefit of the accused. In order to ensure him a fair trial, it is not necessary, however, that more than a reasonable proportion of the public be allowed to attend, and those who attend merely from idle curiosity may under certain circumstances be excluded. Section 965. Counsel for defendant. The defendant is entitled to be represented at the trial by counsel, and in most states the court must assign counsel to a defendant who is unable to employ counsel. The old rule under the common law was that one indicted for treason or felony was not entitled to be represented by counsel at the trial, but might have their advice, or have them to argue a question of law. A defendant is not required to accept the services of the counsel assigned, and if he refuses to accept them, the trial may proceed without his representation by counsel. Section 966. Counsel for the prosecution. In this country, criminal prosecutions before courts of a higher degree than a justice of the peace court are carried on by a public prosecuting officer, a professional lawyer, elected by the people or appointed by executive authority. The duties of this attorney are usually to draw indictments, present cases to the grand jury, and prepare them for trial and try them before the petty jury. It many times is within his discretion to determine whether a prosecution should be instituted, as in case of technical violations of the law. Private persons may employ counsel to aid in the prosecution, or the court may appoint attorneys to assist in the prosecution or act in the case of the illness of the regular attorney, or his inability to conduct the case. The prosecuting attorney represents the public interests, which, while they require the conviction of the guilty, are opposed to the conviction of the innocent, and should compel the use of none but fair methods in the trial. He should not tamper with witnesses, declare his personal belief of the guilt of the accused, state anything as a fact not in evidence, or use any tricks or deceptions at the trial. Section 967. Defendant's right to copy of indictment, names of jurors or witnesses and bill of particulars. The defendant is entitled under statutes in most of our states to be furnished with a copy of the indictment before trial. In many states he is entitled to a list of witnesses who are to appear against him and the names of those who have been summoned to act as jurors. In cases where the offense is such that from the indictment the defendant cannot ascertain the exact nature of the crime charged, as where there is a general charge of being a common scold, common prostitute or common seller of intoxicating liquors, the court, upon the accused's request, may require the prosecuting attorney to furnish the accused a bill of particulars, and also where there is a general charge of adultery or embezzlement. Section 968. Presence and conduct of judge at trial. The judge must be present during the whole trial, and his absence at any essential part of the proceedings is fatal. If there should be misconduct of the judge prejudicial to the defendant, a conviction should be set aside. Section 969. Joint defendants tried separately. Where several defendants are jointly indicted, it rests in the court's discretion to determine whether under all the circumstances, they should be tried separately. If a joint trial would prejudice either defendant, separate trials should be ordered. If there are separate indictments against one defendant charging offences which might have been joined in different counts of the same indictment, the court may order a trial for both offences at the same time, but separate trials must be had if the offences are not such as might have been joined in a single count. Section 970. Right to jury trial. Any person charged with a criminal offence is entitled to a jury trial. This right was given by the English common law, and is one of the guarantees of the Magna Carta of 1215. This right is secured to the people of this country by both the federal and the state constitutions. However, if a statute so provides, city ordinances may be enforced without jury trials, contempt of court may be punishable without a jury, and whatever may have been under former usage tried without a jury, but one's life, liberty or property cannot be taken without a jury trial. A statute is constitutional which provides for trial of a criminal offence without a jury, if it allows an unrestricted right of appeal and trial by jury before the appellate tribunal. The authorities do not agree as to whether the right to a jury trial may be waived by the defendant. Some hold that he may not do so in cases of felony, others that a jury may be waived in all cases, where there is a statute permitting the case to be tried by the court without a jury. But the right to a jury trial may not be waived by mere consent, and there must be statutory authority permitting it, and where constitution or statute expressly requires a jury trial it cannot be waived. Where a statute permits the waiver of a jury trial, the defendant may consent to a trial by more or less than 12 men, but otherwise the constitutional guarantee of a jury trial prevents the waiver of a trial by 12 men. Section 971. Right of challenge. The accused is entitled to be tried by an impartial jury, of men who have been summoned, chosen and impaneled according to the method laid down by law, and who are individually qualified to serve. Therefore the defendant has a right to challenge jurors, which cannot be defeated by legislative enactment, though the legislature may prescribe the time and manner of making objections. There are challenges to the array, and challenges to the polls, and of each of these there are principal challenges and challenges to the favor. Challenges to the array are challenges to the panel as a whole, and if sustained the entire panel is quashed and a new one summoned. Challenges to the polls are objections to individual jurors. Where a juror is not free from certain conditions which might cause him to have a bias against the defendant or in his favor, he is subject to challenge. Among the grounds of challenge are near relationship, other civil and social relationships, such as a witness summoned by the prisoner, or one in his employment, or one with whom he has a pending lawsuit, a general bias for or against a party, which is ground for challenge to the favor, not for principal challenge, a pecuniary interest in the result of the trial, formed or expressed opinion as to the prisoner's guilt, although an inclination from mere rumor to believe the prisoner guilty of the facts heard about him are true, does not usually disqualify, a previous passing upon the question in some capacity, such as being a member of the grand jury which found the indictment, a biased view of the law, as where one is opposed to capital punishment, active connection with the prosecution or defense, lack of freehold qualifications in some states, non-residence in the county in some states, alienage, infamy, want of mental capacity. Certain persons by statute are exempted from jury service in most states, but if they consent to serve, and are otherwise qualified, they cannot be challenged for cause. Among the grounds for principal challenge to the array are irregularities in summoning the jurors, relationship of the officer who summoned them to one of the parties, or the fact that one or more jurors were summoned at the instance of the prosecutor or defendant. The chief ground for challenges to the array for favor is bias on the part of the officer who summoned the jury. Challenges are also divided into challenges for cause, which must state specifically the ground of objection, and peremptory challenges. All challenges to the array must be for cause. Peremptory challenges are those to which the party objecting is entitled as a matter of right, without showing any cause or ground. The number allowed is regulated by statute. The time for making a challenge and the mode of making it, and also of trying objections to a juror, are regulated by statute. Generally, no objection can be taken to a juror or to the panel, after acceptance and swearing, because of any fact then known to a party and not properly brought to the court's notice, or even because of such fact, unless the objection was thereby prejudiced. An objection unknown at the time of the panelling should be taken as soon after its discovery as practicable. Section 972. Swearing the jury. At common law, every juror must be sworn and this must appear of record. Statutes usually permit a juror to affirm who is conscientiously opposed to taking an oath. Section 973. Opening statement. After the jury is sworn, the prosecuting attorney makes a statement of the case to the jury, stating briefly the facts which he expects to prove, the evidence by which he expects to prove them and the accusation and law governing the offense. The statement should be such as to show to the jury in what way the evidence will support the accusation. The evidence for the prosecution is introduced after the opening statement, and then the defense makes a statement as to the nature of the defense to the charge, and introduces his evidence. Section 974. Functions of the court and jury. In some of our states the court, in criminal cases, is the judge of the law, and the jury is judge of the facts. In such states the jury must follow the court's instructions, and a conviction contrary to such instructions will be set aside. However, an acquittal in disregard of such instructions does not entitle the state to a new trial. In other states the jury, in criminal cases, is the judge both of the law and the facts, but in such states it is the duty of the judge to instruct the jury as to the law. And here the jury has only the power, not the right, to disregard such instructions, so that if the accused is convicted on incompetent evidence, or the jury refuses to consider competent evidence, the conviction will be set aside. It is also the court's function to pass on the competency of witnesses, the admissibility of testimony and the sufficiency of the evidence to make a prima facie case. The jury passes upon the weight and effect of the evidence, and upon the credibility of witnesses. Section 975. Examination of witnesses. The next step in the trial after the opening statement by the prosecuting attorney is the examination of witnesses. The prosecuting attorney announces the name of his first witness, and he is called to the stand by the clerk of the court and sworn. The prosecution then examines him in chief, and turns him over to the defendant for cross-examination. At the close of the cross-examination the prosecutor may re-examine the witness if desired. Both examination and cross-examination must relate only to facts relevant to the issues, and cross-examinations must be confined to the facts to which the witness testified in his examination in chief. Re-examination must be confined to the explanation of statements made in cross-examination. Any witness may be recalled for further examination in chief or cross-examination, and in such case the opposing party has the right of further cross-examination or further re-examination as the case may be. The general rules as to the examination and impeachment are the same in criminal as in civil cases. Leading questions should not be asked, in examination in chief or re-examination, unless the witness appears hostile to the party introducing, or where they are necessary to bring items, dates, or details to memory, but upon cross-examination leading questions may usually be asked. Also in cross-examination the witness may be asked questions which tend to test accuracy or credibility or to affect his credit by showing his bad character. Statements of the witness relative to the subject matter of the action and inconsistent with his present testimony may be proved. A witness also may be impeached by showing that his general reputation for truth and veracity is bad. One may not impeach his own witness unless adverse, but may introduce witnesses who will testify to the contrary. After all of the witnesses for the prosecution have been examined in the same manner as the first, and the last one has completed his testimony, the state rests its case. The witnesses for the defense are then similarly examined. Section 976. Arguments of counsel. After the evidence has all been heard the counsel in the case make their arguments to the jury. The prosecuting attorney makes the first argument, and in some states he is entitled to a reply to the arguments of the counsel for the defendant. The summing up must be confined to the facts which have been proved, on which it is contended the evidence tends to show. Matters of common knowledge, such as historical facts, may be referred to. Even this is not allowed if done in such a manner as to inflame the passions of the jury and cause them to lay aside reason. Only legitimate arguments should be used. Abuse of the defendant is improper. Full comment may be made on the evidence and its probative effect, but the prosecutor should not argue from his own special knowledge, or argue from what is not probative. The counsel should not express his personal opinion as to guilt or innocence of the accused. Objection should promptly be taken to improper argument on the part of the counsel. The court may also interfere of its own motion. Usually, if the court admonishes the offending counsel and instructs the jury to disregard the improper remarks, a verdict of conviction will not be reversed. However, if the court refuses to interfere when it should, or the harm is such that the court's instruction cannot remove it, a new trial may be granted. Section 977. Charge of the court to the jury. Upon the completion of the arguments of the counsel the court instructs the jury. In charging the jury the court should instruct it fully, as to the law bearing upon the case, stating the issues, the law as to each issue, their duties to each issue and their duties to the final conclusion, and as to the punishment where the punishment is fixed by the jury. The judge, unless there be a plea of guilty, cannot direct a verdict upon the evidence however conclusive it may be. All extraneous matter, such as irrelevant testimony, should be excluded. The court should not refer to any facts not in evidence nor allegations not in the record. The law should not be laid down abstractly but as applied to all the facts in controversy. It is usually error to read from a law book. It is error to state the law incorrectly. Ordinarily a mere omission to instruct the jury as to the law relative to some point in the case is not a sufficient ground for a new trial unless such instruction is requested. The language of the charge must be unambiguous and direct and such that the persons to whom it is directed will understand. Section 978. Custody and conduct of the jury. In most states and cases of felonies, especially those that are capital, the jury at all times when not in the actual presence of the court should not be allowed to separate, and must be kept in charge of a sworn officer of the court. In cases of misdemeanor, however, it is within the discretion of the court to allow a separation during the trial. And in some states this rule applies in felonies. If these rules are violated and the defendant has been harmed, he is entitled to a new trial, otherwise not. In some cases, if necessity or comfort requires it, the court may allow the jury to separate, or to walk abroad, the officer going with them and they communicating with no one. The jury, after they have retired, should not be allowed to hold any communication with outsiders, even with the judge of the court, or with the officer in charge of them, other than is necessary. Material misconduct on the part of the jury which affects the verdict is a sufficient ground for a new trial. Even the reading of newspapers by one or more of the jurors during the trial is a sufficient ground for a new trial, unless the prosecution shows that the defendant has not been prejudiced thereby. Determining the verdict by casting lots is clearly such misconduct as will invalidate the verdict. The use of intoxicants by any of the jury may be grounds for setting the verdict aside. Section 979. What the jury may take to their room. With the permission of the court, the jury may take the records into the jury room of the case, the instructions of the judge, real evidence used as exhibits at the trial, the entire written evidence, and in some states, where the jury are judges of the law, books of statutes. Section 980. Verdict based on the evidence. A juror must not be influenced by facts within his own knowledge. His verdict must be wholly based upon evidence regularly given in open court. In case he has personal knowledge of material facts in the case, he should go upon the stand and testify. If he fails to do so, and communicates such private information to the other members of the jury, the verdict should be set aside. Section 981. The verdict. After the jury have deliberated and agreed upon a verdict, they return to the courtroom, and report their verdict in open court. This verdict, unless a statute provides otherwise, may be either general or special. A general verdict is the finding of guilty or not guilty on the whole charge. A special verdict, which is rare in criminal cases, finds the facts of the case only, leaving the law to be applied by the court. Partial verdict is one which convicts as to a part of the charge and acquits or is silent as to the residue. The verdict must be the unanimous decision of the jury. It must be rendered in open court in the presence of the defendant, unless he has waived the right to be present. It is delivered orally, unless a statute requires it to be delivered in writing, and all the jurors must be present when it is received. The verdict may be returned on Sunday or a legal holiday. In most states a party may demand a poll of the jury, that is, each juror is asked, "Is this your verdict?" At any time before the jury is polled and the verdict recorded, it may change the verdict, or one juror may defeat it by dissent. The verdict should be certain and complete and responsive to the issues, but merely technical errors will not render it bad if upon a reasonable construction what is intended can be clearly seen. However, if an essential element is omitted, the verdict is bad, as where the statute requires the jury to find the degree of the crime and the jury fails to do so. In the absence of such statutory requirement, however, a general verdict of guilty is a conviction of the highest degree of crime charged in the indictment. Where the punishment is fixed by the law or the court, and the jury do so in the verdict, it may be rejected as surplusage. But if the law requires the jury to fix the punishment, and the verdict fails to do so, it is bad unless duly corrected. In some jurisdictions the jury may, in the verdict, recommend mercy. Such a recommendation, if improper, may be rejected as surplusage. Where the verdict fixes the punishment beyond the extreme limits of the law, it is bad. The court may amend the verdict as to matters of form, but not as to matters of substance without the jury's consent and direction. In certain states, perhaps in all, in cases of misdemeanor, if the court has adjourned when the jurors determined on their verdict, they may reduce it to writing, seal it up, separate, and bring it into court when it opens. Section 982. Evidence. Generally, the rules of evidence are mainly rules which exclude certain classes of testimony. The general rules of evidence, applicable in civil cases, are applicable in criminal cases. Generally speaking, testimony is admissible to prove the facts in issue and also to prove facts not in issue but which are relevant to facts in issue, provided they are not too remote to be material or are not excluded by some arbitrary rule of law. Facts may be proved in evidence which are necessary to introduce or tend to explain other facts which are relevant. Facts which tend to show a motive for the commission of the crime charged, or evidence tending to show that the defendant made preparations to commit the act charged, are relevant and may be proved. Subsequent conduct of the accused, apparently a consequence of the crime charged, not self-serving, may be shown. Acts and declarations which are a part of the same transaction are said to be a part of the res gesti and are admissible in evidence. Statements adverse to the accused made in his presence and not denied by him, such as accusations of crime to which he remains silent, may be offered in evidence. Hearsay testimony, that is, testimony of a witness who does not tell what he knows personally but merely relates what he has heard from others, is admissible only in a few exceptional cases. Among these exceptions are, dying declarations, made by the deceased in a homicide case as to the cause of his death if it is shown that they were made when the deceased was in extremis, and had no hope of recovery, evidence given in a former trial, under certain circumstances, such as when the witness who testified is dead, insane, or cannot be produced at the trial. In prosecutions for the woman's conduct, especially the fact that she made complaint after the commission of the crime, may be shown in evidence. Evidence of another crime, other than that charged, is admissible when it falls under any of the rules above stated. The acts or declarations of any one of two or more persons who conspire to commit an offense, said or done in the presence of the others in the furtherance of their common design are admissible against any of them. Voluntary confessions by the defendant that he committed the crime with which he is charged are admissible in evidence. Involuntary confessions are not admissible. An involuntary confession is one induced by hope of reward or fear of punishment with reference to the particular charge held out by some person in authority. Persons in authority, as the term is here used, includes the prosecuting witness, the prosecuting attorney, the magistrate or judge, and the officer who has the accused in custody. A witness must only state facts and not opinions. As a general rule, when some question of science or art is involved, the opinion of a person specially skilled in such matters may be given in evidence. The defendant always may show that he has a good character, but the prosecutor may not show that he has a bad character until the accused has introduced evidence of good character, unless the character of the accused is itself in issue. Also in homicide cases where the defendant claims that he acted in self-defense, he may show that the deceased was a violent and dangerous man. Section 983, Presumptions and Burden of Proof. A person charged with crime is presumed to be innocent and the state must prove every element of his offense and convince the jury of his guilt beyond a reasonable doubt. This requires a much higher degree of proof than in civil cases where the plaintiff is only required to prove his case by a preponderance of the evidence. When there is a defense of insanity to a criminal charge, the correct rule is, after the defendant has introduced evidence tending to show insanity, the burden is then upon the state to show beyond a reasonable doubt that the defendant is sane. An insane person cannot commit a crime. Some courts erroneously hold that the burden of proof is upon the defendant to establish his insanity by a preponderance of the evidence.